This is number 20 on the docket, People versus Jamilyah Nelson, 07 CR 6011. Please.
Good morning, Judge Maggie Conboy, praying on behalf of the people.
And good morning, Your Honor. Eric Klein and Aurora Randolph on behalf of Ms. Nelson. She is present in custody.
Good morning, Your Honor.
We are set for plea and sentencing today, is that correct?
Yes, Your Honor.
All right. And
Your Honor, subject to your approval, the parties have agreed that we would be moving to have Ms. Nelson plead to an added count of murder in the second degree with a stipulated range of 24 to 32 years in the Department of Corrections, and additionally, we would move to dismiss count 1. As a practical matter, Judge, and we spent a long time discussing what this would mean from a time computation standpoint. That would leave with Ms. Nelson having served already 12 years in the Department of Corrections, and she would then be subject to an additional approximately 4.5 to 9 additional years based on computation and that sentence. If I may please approach.
yes,
And just to clarify, that would be for parole eligibility, not a mandatory release date.
Thank you.
and if you could make a VRA record, please.
I will, Judge. The people have had extensive conversations with the Key family and have met with them. They made a decision that they did not wish to appear today, but I am prepared to make some comments on behalf of the family. But this disposition was made with their approval.
Thank you. Ms. Nelson, good morning. If you'll please move over to the microphone and state your full name for the record.
Jamilyah Nelson,
How old are you, ma'am?
35 years old, Your Honor.
Where were you born?
Boston, Massachusetts.
And how far did you go in school?
I received my general education diploma in county jail.
So you read, speak, and understand the English language.
Yes, Your
Are
Honor.
you thinking clearly today?
Yes, Your Honor.
Have you had any drug, pill, or alcohol in the last 24 hours?
No, Your Honor.
Are you taking any prescription medication that could cloud your judgment?
No, Your Honor.
Do you have any mental or emotional condition that would make it difficult for you to understand what's going on today?
No, Your Honor.
Did you hear the plea agreement announced by the prosecutor?
Yes, Your Honor.
Do you understand that agreement?
Yes, Your Honor.
Did you have enough time to speak with Mr. Klein and Ms. Randolph about that agreement and about your case?
Yes, Your Honor.
Did they answer all your questions?
Yes, Your
And
Honor.
are you satisfied with their representation?
Yes, Your Honor.
All right, I'm going to read to you then at count 2, to which you'll be pleading guilty. It states that on or about October 10, 2007, Jamilyah Nelson unlawfully, feloniously, and knowingly caused the death of Kevin Key in violation of our statute 18-3-103, subsection 1. That's murder in the second degree, a class 2 felony. I have a document here as part of the plea paperwork that sets out the elements of that crime. That is, the things that the people would have to prove at trial and that you're admitting by pleading guilty here today. It looks like you have signed these elements, is that correct?
Yes, Your Honor.
And do you understand them?
Yes, Your Honor.
I also have a longer document, which is your petition to enter plea of guilty and plea agreement. It looks like you signed this at the end and initialed the paragraphs with your initials JN, is that correct?
Yes, Your Honor.
And by initialing those paragraphs and signing the document, are you telling me that you've read all of it and understand it all?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
This document describes, among other things, the possible penalties for the Class 2 felony that you're pleading guilty to. They are 16 to 48 years in the Department of Corrections, with possible fines up to $1 million. Any sentence to be followed by 5 years of mandatory parole. Do you understand those penalties?
Yes, Your Honor.
Understanding then the elements of the crime and the possible penalties, how do you plead to added count 2, murder in the second degree? Guilty or not guilty?
I plead guilty, Your Honor.
And you understand that there's a domestic violence, you're stipulating there's a domestic violence factual basis to that charge.
Yes, Your Honor.
By pleading guilty, you give up important rights, and so before I accept your guilty plea, I need to make sure that you understand those rights. You have the right to a lawyer. If you couldn't afford a lawyer, I would appoint one for you at no cost to you, and in fact, ADC has been appointed to represent you at state expense. You have, I guess in theory, a right to plead not guilty today, although I think that the plea agreement is contingent upon the acceptance of the offer. Is that a fair statement?
Yes, Your Honor.
And there's, in fact, in this particular circumstance, not truly a right to a new trial.
Yes,
Counsel
Your Honor.
agree?
We agree, Your Honor.
All right, and then I won't go through the trial rights. But do you understand that by entering into this plea, you forego the claims that were raised in your motion for reconsideration under, for relief under 35C?
Yes,
Counsel
I do.
agree with that characterization?
Yes, I do, Your Honor.
We agree, Your Honor.
All right. And is it true that you stabbed Mr. Key and caused his death?
Yes, Your Honor.
All right. The court finds there's a factual basis for the plea, and I will accept the plea. We already have a PSI, pre-sentence investigation report, although what we don't have is an interview. Are both sides willing to proceed without that interview?
We are, Your Honor.
Yes, Your Honor.
All right, I am ready to proceed. I will hear first from the people. Conway?
Thank you, Your Honor. And I know that this is contained in the Rule 11, but I do just want to make a brief record that this agreement, as the court is aware, was based on the original claim of ineffective assistance of counsel. It is important that the people make a record that we are specifically not agreeing that there was any ineffective assistance of counsel in this case. And with that, Your Honor, thank you. This is a very unique case. And the people want to commend Ms. Nelson. She has seized every opportunity that she has been given in prison to grow as a person and to work towards her rehabilitation. She's been mentoring, she's obtained a GED, established programs to benefit children of incarcerated mothers, mentoring other incarcerated women who have re-entered society, and maintaining strong personal bonds with family outside of the prison walls, including continued to parent her own child who has become a straight-A student. Ms. Nelson is clearly a positive person who has impacted the lives of many other women in prison, and as defense counsel said, she has made lasting and positive changes in the facility. The people also believe that her remorse is deep and real and genuine, and that she has accepted responsibilities for her actions. This agreed sentence of 24 to 32 years reflects what we believe is fair, but she be given the opportunity to return to the community where she will hopefully continue to make a difference in the lives of others. As I mentioned, with the time she has already spent, it is the party's specific intention that the range will be somewhere between 4.5 to 9 additional years before her parole eligibility date. The Keys are not present with us today. We met with them, as well as their other son, Kevin's brother. They are thoughtful, circumspect, kind people. They knew Miss Nelson, of course, And while they are suffering a loss that no parent should ever experience, the loss of a child, they agree that Ms. Nelson should be given an opportunity to get out of prison one day. When I asked what they wanted to see happen, they said they thought it was fair if she were to serve another 6 or 7 years before her parole eligibility date. I spoke with Mrs. Key again on Friday, and she again said while they did not want to attend today, she did ask me to email or to mail Ms. Nelson's letter and to let her know what the court decided in terms of a sentence. So while they are not present in the courtroom today, I am standing here at this podium representative of that family and representative and with the understanding of the horrible loss that they suffered. With those brief comments, Your Honor, the people are going to defer to the court on the appropriate sentence in this case. Thank you.
And any restitution would be reordered.
Thank you, Your Honor.
Mr. Klein?
Thank you, Your Honor. When Jamilyah Nelson was a girl, she had dreams. Dreams of growing up to be glamorous, dreams of growing up to be a model. Never in her wildest dreams could she see herself where she is right now. Never in her worst nightmare could she see herself taking the life of the man she loved. But on October 10th, 2007, a situation that had been bad and had been getting worse grew out of control. That night, both Mr. Key and Ms. Nelson had been drinking. Mr. Key's blood alcohol level was 0.214, almost 3 times the legal limit. And things got violent. Mr. Key at some point grabbed Ms. Nelson by her arms and by her throat, digging grooves into her arms as well as into her throat, gripping her so tight that he actually tore a fingernail off of his hand. Ms. Nelson hollered for Mr. Key's friend, Jonathan Van, to come help. And at some point, Mr. Key left her alone for a minute, and Ms. Nelson went and grabbed a knife from the kitchen counter where she'd been preparing dinner, and she took herself into the living room of their apartment and sat on the couch. And even though she was holding that knife, Mr. Key confronted her again, coming up to her, tormenting her, flicking her in the face and the lip, challenging her, telling her, "You better go ahead and stab me." And it was during that tense altercation that it happened. She stabbed him. It wasn't a full thrust. She didn't bury the knife in him. But it went deep enough to pierce his heart. And in that moment, many lives changed forever. Mr. Key lost his life. His parents lost their son. And Ms. Nelson and her family started on the odyssey that brings us all here today. And the courts received a lot of materials from us in preparation for sentencing. And we appreciate the court's attention to that. And the court's heard from a lot of people, including a prison psychiatrist, a domestic violence expert, former inmates who have been impacted by Ms. Nelson. The court heard from Ms. Nelson's parents and from Ms. Nelson herself. And in court today are Ms. Nelson's parents. Her mother's been sick with pneumonia, so I really appreciate the effort it's taken to get her here. Unexpected, also present is Victoria Lutz, the domestic violence expert, who the court has read a report from and who traveled on her own dime down from Fort Collins to be here. And I think that really speaks volumes about what she sees in Ms. Nelson and the importance of Ms. Nelson's case, that she would be here today, and we very much appreciate her being here. The court, until now, has not really heard directly from me about Ms. Nelson. And I'd like to tell the court a little bit about the person I've gotten to know over, I believe now, 6 years. I try to live every day for Kevin. Ms. Nelson has told that to the court. She's told that to the Keys. And that's something I've been hearing over and over again for 6 years now. Prison is a hard place to be. I do a lot of post-conviction work and also work with people facing prison homicides. And so I've gotten to know a lot about prison. It's a hard place to be, but it's a harder place for somebody who's serving life. There's no real incentives for somebody to do things to better oneself. And the system itself largely writes these people off. putting them at the bottom of the list to do these sorts of programs, even if they want to. But even though for years there was no light, or at best a very dim light, at the end of the tunnel for Ms. Nelson, she insisted on finding and making opportunities to improve herself. I try to live every day for Kevin. And she knew that freezing herself in time on October 10th, 2007 would do nothing for Kevin's legacy. It would do nothing for his family. And it would do nothing for her family. So she worked on her education, on her mental health, on herself, to make herself a better person. But that wasn't enough. I try to live every day for Kevin. So she got to work helping other people, becoming a mentor to other women in prison, making their transition easier, helping them make the best of their situation. And there have been times over these years where I'll see Ms. Nelson and she's having a real difficult time for herself. But she never lost sight of the other people who she was helping. And she wasn't just there as a mentor. She helped establish programs for women and their children, making sure the bonds of motherhood would not wither for those women while they were in prison. And the courts heard about the programs, Moms and Kids Day, school backpacks, and amazingly helped find homes for babies of 2 women who came into prison pregnant. And one of those children, Majestic Justice, MJ, has been living with her own parents, and now that the mother of that child, who was released on parole just a few weeks ago, is living with them as well. Ms. Nelson has also explored issues about domestic violence, learned what prompts it and what women can do to extricate themselves from a relationship before things get to the point where they did for Ms. Nelson. And she's shared her story in an effort to help others, bearing her soul on a podcast to really talk about her own life and how she got here and how people can avoid this situation. And as Ms. Conboy recognized, and we appreciate, throughout all this, she has had nothing but remorse for what she did. And she's had nothing but empathy for Mr. Key's family. Your Honor, I've been representing criminal defendants for 20 years now, and I've represented, I was trying to figure this out, thousands of people. And I can say and I'm sure the court's seen this, it's incredibly rare to see someone who's reflected on themselves and their offense the way that Ms. Nelson has. And sadly, I've gotten to know a good number of people who have taken a life. And most of them are extremely remorseful, but I've rarely seen people who are able to see things from the perspective of their victim and their victim's family the way that Ms. Nelson has. That genuine empathy is what gives Ms. Nelson the drive to help not just herself, but anyone she can. We deal with the system, and the court, I'm sure, has concerns about sentencing based on a system that has a historical role where punishment serves a primary purpose. And concerns about somebody who is in this situation about a future danger. Part of the court's decision certainly has to take into account our state's shift towards an evidence-based sentencing scheme that focuses on taking the smartest action to reduce recidivism and ensure community safety. And I'd like to address each of these briefly. Ms. Nelson has been punished. She's already served more than 12 years of incarceration. And women who have taken the life of a partner in similar or more egregious circumstances have received sentences of 24 years or far less. Ms. Nelson will be punished for the rest of her life, not just with a felony conviction for murder, but also carrying the weight of what she did. Ms. Nelson is no danger. I don't think there can really be any question that if she were to walk out here today, nobody is in any danger from Jamilyah Nelson. During 12 years in prison, she's performed admirably. Risk assessments consistently indicate that she's a low risk to reoffend, and that's reoffend at all, not violent offense, shoplifting, anything. And those types of assessments have been proven to be reliable. And I think this is where the historical role of punishment comes in tension with the modern trend toward evidence-based sentencing. Because research uniformly demonstrates that the longer we lock someone up who is low risk, the more we actually increase the risk that they will commit an offense in the future. we've agreed to this sentencing range, and we will not request a sentence less than 24 years. We felt for a long time there were strong issues raised in Ms. Nelson's 35C petition. And we felt, and we had an evidentiary hearing set, and we felt that we had a good chance of prevailing. But Ms. Nelson chose to accept responsibility for Mr. Key's death. She chose not to put his family or hers through the ordeal of that evidentiary hearing and the possibility of another trial. That, of course, cannot negate the fact that there's significant mitigation in this case. That cannot negate the fact that other women in similar situations have received sentences far less than what we're asking for. And that does not negate the fact that the 35-year-old woman who stands before the court today is a far cry from the 23-year-old involved in that tumultuous relationship that ended so tragically. You know, I want to conclude by echoing the conclusion of the prison psychiatrist, Dr. Leslie Miller. And before I actually say what Dr. Miller said, I want to let the court know that, because I don't think we said this in any of our materials, the letter from Dr. Miller was actually unsolicited. We did not ask Dr. Miller for that. Ms. Nelson did not ask Dr. Miller for that. Ms. Nelson returned to her room one day and found it sitting there in her room. Much like Ms. Lutz being here today. We did not request her to be here. She came here on her own. And what did Dr. Miller have to say? Quote, "I would certainly support the shortest sentence possible for this offender. I am thrilled that she will have the chance to return to the community where I think she will have much to offer." Your Honor, in light of all that Ms. Nelson does and will have to offer, we second that request. Your Honor, I also know the court will offer Ms. Nelson the opportunity to speak, and she's aware that she has the right to speak. She has done so through her letters to the court, to the Keys, and as well as in her video interview the court has seen. And if the time is ever right, and if the Keys were here, I would say this to them, Ms. Nelson does continue to wish to make herself available. She knows that this is not the time or the place for that, even were the Keys here. So understanding and appreciating her opportunity to speak, Ms. Nelson does not wish to do so at this time. Thank you, Your Honor.
Ms. Nelson, you do have the right to address the court, but you are not required to. I did watch the video and I read your letter to the Keys and to me, and so you certainly spoken to me in that way, but I just want to confirm with you because it's your decision that you don't wish to address the court today. Is that correct?
That is correct, Your Honor.
All right, thank you. The court, when it sentences, is guided by our statute, 18.102.5, which sets out the purposes of sentencing. And they are, in the order in which they're listed in the statute, first, to punish a convicted offender by the imposition of a sentence she deserves in relation to the seriousness of her offense. And here the court considers the gravity of the offense and the extent of the injury caused to the victim. There is no more grave and serious offense than the taking of a life. And as Ms. Nelson understands, the injury goes far beyond the injury suffered by Mr. Key. It goes to his family and to her family. The next factor is to assure fair and consistent treatment of all convicted offenders by eliminating unjustified disparity in sentences. And here the court looks at the prior criminal history and the societal history. There is no significant criminal history in this case, other than, of course, the crime for which we're here. And the societal history, while it doesn't have the kind of mitigation that we sometimes see in terms of suffering or witnessing abuse, has the mitigation of Ms. Nelson having lived a pro-social life in the community up to the time of these events. The next factor is to prevent crime and promote respect for the law by providing an effective deterrent to others likely to commit similar offenses. We're looking at a very serious sentencing range, and I can't believe that within that range, this factor really comes into play. And as those who appear regularly in my courtroom know, that's not my favorite factor. I'm more interested in doing justice in each case than using one person as an example to someone else. The next factor is to promote rehabilitation. This is a stipulated Department of Corrections sentence. The possibilities for rehabilitation are meager there, particularly for people sentenced to life. But what makes this case truly remarkable is that Ms. Nelson has found those opportunities, and she has made those opportunities. Her participation in programs was sometimes a result of her fighting her way into them, arguing her way into them. She has engaged in activities, and this is, I think, what is most impressive to the court, that aren't designed to benefit her necessarily, but to benefit others. She has been unselfish in her years, and in an atmosphere where many would feel defeated, she has brought some light in the darkness that counsel described. I've had the opportunity in another case to hear testimony about the Mothers and Kids program that she was instrumental in starting, and I know how important it is to the lives of the women there and to their children. And so that is significant in her other work individually as a mentor. And she has done things that are truly, truly remarkable. I'm going to skip to the sixth factor, which is to promote acceptance of responsibility and accountability by offenders and to provide restoration and healing for the victims. I have a lot of people come into this courtroom and tell me at sentencing that they're sorry for what they did. And some, frankly, are more convincing than others. But Ms. Nelson has lived that remorse. She has truly worked to come to grips with what she did and how it's affected not only Mr. Key, but those in the broader community. And it's remarkably rare that someone expresses their remorse in the active tense. People come in and they're sorry for what happened or sorry for anything they did. She's recognized what she did, and she admits her responsibility, and she takes accountability, and she is truly sorry. The final factor is to select a sentence, and that decision is made, but a sentence length that addresses the offender's individual characteristics and reduces the potential that the offender will engage in criminal conduct after completing her sentence. I think that chance of reoffending is very, very low, and I can't imagine that the people reach a different conclusion in coming to this deal. On the other hand, unlike many people, I doubt that there's a risk to her serving time in prison, increasing her chances of reoffending because she has learned to thrive in that environment. I want to make a couple of things clear. One is that nothing we're doing today lessens the value of Mr. Key's life. Nothing we're doing today indicates that his death isn't deserving of punishment. And I understand that there's a side of this case that wasn't argued at trial. And I didn't hear that trial. I don't know the reasons. But I'm not going to assume that it was ineffectiveness of counsel. There was evidence at trial, including Ms. Nelson's initial lies to the police about what happened that might have made that defense more difficult. Evidence about the knife being taken earlier that could have certainly affected the decisions that counsel made. And so I'm not here to say that counsel erred or that the jury didn't deal properly with the evidence that it had. But I heard some testimony in this courtroom before this deal was struck, and it was clear from that testimony, as it is from some of the materials that I received from the defense, that there was an ongoing domestic violence issue here that is mitigating and that could have affected a jury's consideration of this case if they had heard it. The Key family has been, I think, very understanding and I would say generous in agreeing to a resentencing after all these years. I'm sure this reopens wounds for them. And I do want to honor their feelings about what is fair in this case. They have been over so far. They've done so much to facilitate this agreement. I've considered all of these factors, and it will be the sentence of the court that Ms. Nelson served 26 years in the Department of Corrections with 5 years of mandatory parole. I know it's a couple more than you were hoping for. I know there are good arguments for 24. I hope you will see that an agreement that honors the Key's wishes as well may help you in your efforts to console them and to reach out to them and eventually to re-enter the community with them. I wish you the best in your continuing efforts. Good luck to you.
Thank you, Your Honor.
Thank you, Your Honor. I think for pre-sentence confinement credit, it's 4,507 days as of today.
PSI had a slightly different figure, I think, of 4493.
That was based on the earlier sentencing date.
All right, very well. Any disagreement?
No, Your Honor.
All right, I
Thank
will
you.
order that pre-sentence confinement credit. Thank you.
Thank you, Your Honor.
Thank you.